Welcome everyone to our webinar on current medico-legal issues. My name is Tracy Pickett and I'm a lawyer in our Advocacy, Education and Research team at Avant, and I'm pleased to be your moderator this evening. To begin, in the spirit of reconciliation, Avant acknowledges the traditional custodians of country throughout Australia and their connections to land, sea and community. We pay our respect to their elders, past and present, and extend that respect to all Aboriginal and Torres Strait Islander peoples today. The plan for this evening's webinar is to touch on 3 topics to provide an overview of the selected issues. We've used this format in the past in order to facilitate a discussion with our legal and medical experts about those topics. So while we won't be able to analyse the topics in depth, we have reviewed your questions and we will answer as many as we can. And then after the webinar, we'll also send out an email to each participant from this evening with all of the links to the information which is discussed. And just to clarify, because we have been asked this in the past, the purpose of tonight is to have a discussion with our experts, so we won't be using PowerPoint slides. Thank you to all of those people who have submitted questions in advance. If you do think of additional questions during the webinar, please add them to the chat. The panelists can see your questions and we will provide answers to as many questions as we can during the evening. So with that, let me introduce our panel. First, I'm very pleased to welcome my colleague, Ruanne Brell, a senior legal advisor in our Advocacy, Education and Research team. Ruanne has 20 years experience in health law, and she advises our members on a wide variety of medical and health law issues. She also advocates for members in the preparation of submissions and other educational material as part of Avant's advocacy and education strategies. Having worked with Ruanne for some time now, I know that we're very lucky to have her as a presenter with us this evening. Hi, Ruanne.
Hi, Tracy. Hi, everyone.
Next this evening, we have the great pleasure of speaking with Dr. Solomon Menahem. Dr. Menahem is a renal physician and he's also one of our in-house medical advisors at Avant. Dr. Menahem is the Director of Renal Services at La Trobe Regional Hospital and has served as the practitioner member of the Medical Board of Victoria. Welcome, Solomon.
Thanks, Tracy. Good evening, everybody.
And last but by no means least, we have our final panel member, Dr. Daniel Kennedy, Specialist Plastic Surgeon at St Andrew's Hospital and CEO and Medical Director at Pacific Day Surgery in Brisbane. Dr. Kennedy is a member and past president of the Australian Society of Plastic Surgeons and a member and past secretary of the Australasian Society of Aesthetic Plastic Surgeons. Welcome, Dan.
Thank you.
We also have a very knowledgeable and attentive elves in the wings this evening, Dr. Patrick Clancy and Chris Wright. Patrick and Chris will be doing their best to respond to the questions which are raised during the webinar in the chat. And as I indicated earlier, within the next week or so, we'll also send out the links to any information which is discussed this evening. So without further delay, let's get things moving and look to our topics of discussion, which are prescribing, advertising, and artificial intelligence, and all within the hour. So the first topic this evening is prescribing. By way of overview, Ruanne, could you set the scene for our discussion on prescribing this evening?
Yeah, sure. Thanks, Tracy. So certainly in preparing for this webinar and in putting together education about prescribing, we certainly know that it is a big and complex topic. It could be worthy of a webinar in and of itself. So as Tracy mentioned, if you would like this, feel free to let us know. Primarily tonight, we're going to be talking about prescribing drugs of dependence, just to try and limit the discussion and give it some focus. So when we talk about that, we're talking about opioids, sedatives, stimulants. Most will be Schedule 8s on the poison standards, but of course this also includes some Schedule 4 medications such as benzodiazepines. One of the reasons for the complexity when we're talking about prescribing is that each state and territory in Australia has its own legislation that governs what's required, what can and can't be done. So the first message I think it's really important that you all leave with tonight is it's very important for you to familiarise yourself with the requirements that apply in your state and territory. And we'll touch a little bit later on how to deal with situations where you might be working across state borders or live close to a border. And it might be, you might need to be a little bit familiar at least with some of the other some of the other legislation that might apply. It's also one of the other requirements is the need to get an authority, and this is different to a PBS authority. So there's a requirement to prescribe as well, and that's different to your sort of your PBS authority. In all states and territories except Queensland, doctors do need a state or territory authority or approval, as well as that PBS authority. So that's just a couple of high-level messages, and we're going to dig down deep as deep as we can in a short space of time into some of those issues.
Thanks, Ruanne. And I think even with that short summary, the complexity of this system is very clear. So given our tight time frame, can we move on to look at one of the relatively recent changes, or less recent in some jurisdictions, which is the introduction of real-time prescription monitoring? Can you give us some thoughts on that issue, Ruanne?
Yeah, sure. So when we're talking about real-time prescribing, so this is the monitoring that occurs in each of the states and territories about monitored medicines. So again, these are primarily S8s. And when we're talking about real-time prescription monitoring, or RTPM, that's SafeScript in New South Wales, ScriptCheck in SA and WA, and QScript in Queensland, SafeScript also in Victoria. Tasmania at the moment is called DORA, but it's moving to be called TasScript relatively soon. The main things to remember are, in certain states and territories, so those are Victoria, Queensland, South Australia and Northern Territory, it is mandatory for doctors as the prescriber to check that system before prescribing. And there are fines that apply for non-compliance. And these, again, are different in each state and territory, but can be tens of thousands of dollars for not doing that. It's not mandatory to check the system in New South Wales, Western Australia, the ACT, and in Tasmania, because they've sort of started to prepare for a bit of a transition. Doctors are required to take all reasonable steps to check monitored medicines. There is a small fine that applies, but DORA use at this stage is not mandatory. From Avant's point of view, as a matter of safe practice or good practice, even in those states where it's not mandatory, we'd recommend that you do check the relevant system when you're prescribing a monitored medicine, as it helps to inform how you might manage the patient. Just because you get an alert, it doesn't mean that you can't prescribe. It just means you need to factor that into your system. It's also important just to remember that seeing the alert is not the same as checking the system, and you actually need to respond to that alert, go through and actually check the relevant system in your state and territory.
Thanks, Ruanne. So that's the legal position. Now let's get a clinician's perspective. Solomon, you're based in Victoria. Do you use SafeScript as part of your everyday clinical practice? And if so, do you think it assists you in terms of making you a better doctor?
Thanks, Tracy. So I'm a specialist physician, so prescribing of opioids is not a huge part of what I do, but certainly it has evolved to be really quite an important part of clinical practice and safe medicine. Really, before SafeScripts in Victoria, there was no real way of checking what people had or hadn't been prescribed, particularly with private scripts. And so many people really didn't understand just how many private scripts are available out there for opioid analgesics in particular. And whilst we think we're pretty good at distinguishing between acute chronic pain, opioid dependence and opioid abuse, we're really not very good at doing that. And many people are accessing scripts from a variety of different mechanisms, from different doctors, through private and public systems, private scripts and public scripts. So I think the SafeScripts kind of brought all this together in Victoria. Now finally we can have some good understanding of what people are taking, what people are being prescribed, how much they're being prescribed and where they're getting them from. And so this idea that patients are shopping around to different doctors has overnight disappeared. It gives a lot of transparency to the doctors prescribing as to what other opioids they've had, when they've had them dispensed, and really allows you to safely prescribe opioids and other drugs of dependence going forward. At a simple level, it's really just very helpful to see other agents that might interact with what you're prescribing, but at a more complex level to understand really how much they're using and what are the risks, are the requirements escalating or decreasing, and how can we better manage that. I really think it's been a great innovation. It's pretty user-friendly and really allows individual doctors to have a really good overview of what actually the patient is having, where they're getting it from, and how to try and control that on a bigger scale.
Yeah, thanks, Solomon. And can I put a different scenario to you? As a renal physician, what about a patient who presents with acute pain, say from a condition like kidney stones, which I understand is a painful condition? Would you be required to check SafeScript before prescribing an opiate to treat that pain?
Yeah, so it depends a lot on where the individual presents. Remembering that safe scripts does not have to be used in places where the patient is in a single controlled environment. The idea of safe scripts is to avoid people shopping out in the community. So if they're an inpatient in a hospital, you don't have to check safe scripts. However, severe acute pain is one way that drug seekers do present. So I think in big hospitals, emergency departments and inpatient hospitals, you're not mandated to check because you are in a contained environment. But I think if there are any suspicions or concerns that this may be drug-seeking behaviour, you certainly are. It's worthwhile checking. The problem is people who are still moving through the hospital system, unfortunately, haven't really been exposed to SafeScript and don't really understand how it works and how to use it. So I think it's really good, even at a junior level, to have access to the system. When you do see people with acute pain, make sure that this is not drug-seeking behaviour, or even if it is that these people haven't had drugs recently prescribed, or that they haven't had an excess number of drugs, even if it's genuine pain that they've somehow accumulated in other areas. So there's a lot of good reasons to check SafeScript, even if you're in a centre that's not necessarily mandated to do so.
Solomon, I might just go to the chat and you'll see that some members of the audience have asked what they should do if the real-time prescription monitoring system isn't working. Would you agree that in those circumstances you would document in the records that you've attempted to access the system and then try again later?
Yeah, I don't think you have much of a choice. The patient's in
No.
front of you. You have to care for the patient. I think you've done the best you can to confirm that the patient is or isn't an opioid user or haven't got a stockpile of opioids. If it's not available, the best you can do is document that the system's down. Prescribe if you have to at a limited amount, and then check the system when it's up and running and make sure you log through it. If you have concerns, you can obviously follow up with the patient or pharmacist at a later date. But it is difficult. I must say the system does seem to work pretty well generally in Victoria.
Thanks so much. I might turn to Dan now. Dan, as a plastic surgeon, if a patient has had surgery and they require pain relief medication, in the usual course, who prescribes the post-operative pain medication?
Well, very frequently, it's the anaesthetist who provides their discharge script or their post-operative script in hospital. And so it'll typically be the anaesthetist who checks their Q script in Queensland, because I'm in Queensland. And in fact, our doctors are obliged to check even on inpatients before they prescribe in the private sector. There's a difference in the public sector. But it's been a very useful tool. There has been a little bit of trouble with downtime of the system, but that seems to have improved dramatically since its introduction. And it does give you some insight, because obviously the anaesthetist and I will discuss a patient's need for pain relief, and they'll often seek my opinion as to how painful this procedure is going to be in the post-operative period to try to guide their prescribing. And knowing what this patient has experienced in the past 6 months or 12 months is very informative as to what they're likely to need and what their behavior is likely to be like. You do get some insights into behaviors that are maybe disturbing in the recovery area when somebody is effectively short on opioids. And you get some hint that that's going to happen. So it has actually been a very useful source of information. And sometimes you have no idea at all that the person's on multi-pharmacy because they won't have mentioned it to you.
Would you say those insights have come from the real-time prescription monitoring system?
Yes, no, there's been a definite improvement in understanding of drug-seeking behavior, I think, because of the access to the real-time prescribing. And it's usually a discussion, because oftentimes it's the anaesthetist who's accessed the system, but has a discussion with me about what they've already got at home and what they've already, been using prior to the surgery.
I'm sure that's something that some of the audience tonight had not considered. The other issue, thank you, Dan. The other issue we wanted to consider before we leave the topic of prescribing, and that is the difficulties associated with prescribing when patients travel between states, or if a practitioner practices on the border between states. So if a patient receives a prescription and seeks to have it dispensed in a different state, the legislation which applies in that jurisdiction will need to be considered. So given the differences between legislation in each state and territory about prescribing, this can be a real issue. So we might look to the legal situation first. Ruanne, can you shed some light on the topic?
Yeah, thanks, Tracy. So this gives rise to two issues. One is how you deal with this if you need to prescribe something that would be required, that you'd require to interact with the real-time prescription monitoring system. But also it's about what authority, whether or not you would need an authority in that state or territory. So when you are as the prescriber are in one state, the laws that apply to you would be those in the state where you are doing the prescribing, so where you're sitting. If the patient was filling that in a different state, then there may be separate dispensing rules. And that's why we said at the outset that the really important thing is that you're familiar with the laws that apply in your jurisdiction. And the link to our prescribing drugs of dependence fact sheet has just been put in the chat, and that has links through to all the states and territories in there. And we've also got a landing page which has the information summarised on there with useful links as well. When it comes to real-time prescription monitoring, in certain jurisdictions, such as New South Wales, you are able to register for not just your own state system, but another state's. You're able to register for the New South Wales system, even if you don't have a practicing address in New South Wales. But in Queensland, for example, you need a practicing address in Queensland to be able to register for that state. So you're obviously not required to check a system in a state that you can't access. But if you knew the patient was crossing borders or moving in and out of states, you can still, for example, if you were concerned about potential abuse or doctor shopping behaviour, you can still contact the prescription shopper program and get some additional information that way. So,
Ruanne, it really does come down to the fact that when you're prescribing certain medications, doctors have to bear in mind the possibility that some patients may travel to different jurisdictions, which may have different legislative requirements for that particular medication.
Yeah, correct. And there's been some questions in the chat about particular types of medications, so psychostimulants for ADHD, for example. Because these vary, we really encourage you, if you are prescribing these sorts of medications, to check the situation in your state. And as I say, we've provided those links and we'll be sending them after the chat. It's also probably just worth mentioning at this point in time that there is some work being done on actually nationalising this system. So even though the implementation of it will be state-based, the idea is that the systems will talk to each other through the National Data Exchange. And so hopefully that'll overcome some of those pain points. So, watch this space, and we're talking to the Digital Health Agency just to try and get a bit more information about that as well.
Thanks, Ruanne. So moving on to the next issue involving prescribing, and that is the issue we've received the most questions on, and that is, I thought we might have a poll question to see what our audience thinks. The poll question is self-prescribing illegal? You can say yes, you can say no, or you can say I don't know. So while we're waiting for those answers to come in, and it may well be a controversial question, many of our members do have differing views on that question. And so far, we've got 30% of our participants saying it is illegal and 50% saying it is not illegal. So the answer is that self-prescription of S8s is unlawful in all states and territories except New South Wales, and the emergency defence only applies in South Australia and Western Australia. Also, for high-risk S4 medication, it's illegal to self-prescribe in some states, and that is the ACT, Northern Territory, Victoria, and in Queensland and Western Australia, unless it's an emergency. So while that's what the legislation says, there are differing views of clinicians, particularly in relation to issuing repeat scripts for chronic lifelong conditions. Also, what about the issue about prescribing for family and friends? So, Dan, we might turn to you. Are you able to give us an insight about what clinicians, not necessarily you, but other clinicians might think about this issue?
Sure. I think there's a really clear-cut issue here in Queensland that and everywhere really under the Good Medical Practice Guide 4.15, there's a must not prescribe monitored medications. That's your S8s and your benzos and your sedatives and hypnotics and what have you. So that's really clear. But certainly in Queensland, it's not illegal to self-prescribe, and it's not illegal to prescribe for your family and friends. However, you really do have to have a very serious think about why you're doing it and what you're doing, and are you competent to do it, and are you keeping adequate records, and can you provide the appropriate care? Are you breaching professional boundaries by providing this prescription? And oftentimes you are. Would your peers agree with what you are doing? Is this such an urgent situation that there's a greater good in prescribing for somebody who's run out of a critical medication where they're going to fit if they don't stay on it, versus the benefit of them being responsible for their medication and having the repeats on hand or electronically available to them? And would the relationship between family or friends survive an adverse event? I think these are some of the important issues when it comes to prescribing. Self-prescribing is a little different in those respects, but family and friends, there's a strong sense that if I'm just providing a repeat for my family, as long as somebody else has prescribed it, that's a very reasonable thing to do. But there is significant surveillance upon us, and there is a strong guidance in the Good Medical Guide that we are meant to provide independent distance and professional boundaries for our patients, and we can't do that with family, friends, or family and close friends. It's difficult to know exactly where family is. South Australia is the only state that's defined what family is, and to them, it's a direct lineage or brothers and sisters. So it's grandparents, parents, children and grandchildren, brothers and sisters. But every other state just says family and close friends, and that can be confusing for people when it comes to second cousins. But I think that there's a very clear test when it comes to is this person able to be assessed and treated as in a professional setting with appropriate professional distance, or is this an urgent situation that demands that this person's asthma or epilepsy is managed? If you do that, if you do step into an area of concern, you have to document it. You have to seek the acknowledgement or input of their regular practitioner when it's at an appropriate time, and you have to give consideration to those 4 points that I was talking about before.
It's certainly a very significant area for clinicians, and many of the questions we've received this evening are various nuanced situations, such as, can you self-prescribe or prescribe for family and friends when their regular GP is on leave? I might turn to Ruanne for the legal answer to that question. Thank you, Dan, for that perspective.
Yeah, so obviously in terms of self-prescribing, if it was an S8 and covered by the illegalities of that wouldn't be something to do. But if we're talking about it more generally, even with self-prescribing, it's difficult to conceive of a situation, if we're talking about your regular GP being on leave, where there wouldn't be another alternative other than you self-prescribing. So whether or not that's a colleague in the same practice as your usual GP, and the code of conduct that Dan was just talking about does also have a section in there saying that all doctors, good medical practice involves all doctors having their own GP. Mm-hmm. So that is, one of the, obviously that's in terms of making sure that someone else is objectively managing your health, but it's also so you don't find yourselves in a situation where you're tempted to provide treatment to yourself, and where you might be having to deal with a condition that's obviously not necessarily within your skills and expertise, and a GP can obviously coordinate and manage that for you. When we're talking about family and friends, again, a regular GP just being on leave shouldn't necessarily put you as the family member or friend of that person in a situation where there's no other alternative. There might be exceptional circumstances, but other than those exceptional circumstances, we'd really encourage you to consider what the other alternatives might be for that person to get a script from someone objective and independent.
Yeah, and sorry, Dan?
Oh, no, just agreeing.
I suppose also the other element to consider is it's not necessarily this one script, but also the course of conduct that it sets up, because it is meant to be an emergency situation. So I might ask Solomon, as a senior practitioner, have you developed a way to respond if you're asked for a script by family or friends?
Yeah, it's a real challenge, Tracy. People come to you often in desperation or just because you're there. I think it is about establishing boundaries and accepting that providing a script is a clinical input to patient care, and if you have no oversight of that patient or that individual, it's very hard to safely do this. And once you breach that boundary, then unfortunately you're stuck. That they can come back and it can escalate from simple drugs to more complex drugs. So I've sort of adopted a fairly blanket rule of no, a fairly blanket rule that's really frowned upon by the medical board and code of conduct, even though strictly speaking it may be legal. That the risks to the people approaching me, are that I don't really have oversight of your clinical care, your other medication. Even if it's just a simple repeat script, the exact dose might have changed. The complications that may have arisen in the past are not known to me. So, I think if you're strict in the way you relate to your friends and family from the outset, they come to understand and appreciate that, there's no simple drug, there's no simple prescription, that there are risks with everything that we do, and that it's best to be safe. I think people who aren't related to doctors have worked out a good way to make sure they have a supply of their chronic medications. People know to make sure that they've got access to scripts and pharmacists. And sure, in extenuating circumstances and extreme emergency, we're all happy to make exception. I don't think we want to leave anybody vulnerable to serious misadventure, ill health, seizures. And there are ways to overcome that. But generally speaking, most people can manage to keep on top of their scripts, and so should our friends and family as practitioners. And self-prescribing, again, I think years ago, doctors were pretty relaxed about self-prescribing. I think, again, it's about boundaries. It's about establishing what is and isn't safe and good practice. And whilst it might be reasonable to prescribe antibiotics for a chest infection, once again, you breach that boundary with yourself, that can escalate. And again, you've got no objectivity when it comes to caring for yourself. Unfortunately, if you start that process, particularly if you develop chronic ill health, then you are always vulnerable and susceptible to self-prescribing things, which can get you into a lot of trouble. And I still see that quite a lot, and there's still a lot of issues with people self-prescribing Schedule 8 and other drugs of dependence that they shouldn't be, unfortunately, because they've breached that boundary.
Thanks, Solomon. So in summary, the legal position regarding self-prescribing is we strongly recommend that you do not self-prescribe, and self-prescription of S8s, as we've said, is unlawful in all states and territories except New South Wales, and in emergency situations only in South Australia and Western Australia. And for high-risk S4s, it's illegal to self-prescribe in some states, that is ACT, NT, Victoria, and in Queensland and WA for only emergency situations. As we've said, the good medical board code of conduct says not to do it, and the code also says that practitioners should have their own GPs. So if you find yourself facing exceptional circumstances where you feel that there is no other reasonable choice but to self-prescribe or prescribe for family and friends, you need to be able to justify the steps you have taken if a complaint is made. Ruanne, could you just give us a quick summary on the legal position regarding prescribing for family and friends?
Yeah, sure, Tracy. So we mentioned at the start where that is sort of illegal in South Australia. Obviously, prescribing and in the Code of Conduct, prescribing drugs of dependence or psychostimulants or opioids is prohibited under the Code of Conduct. So that's a professional issue. It's important to remember, and there's been lots of questions in the chat about what about this, what about that. The general position is that you should not treat your family and friends, and we include staff in that. Family is obviously your spouse. It's a one-off prescription, as we've said, unless there is a situation that essentially makes that unavoidable and you would need to be prepared to justify your actions. A couple of people have also mentioned, and I think it's a good reminder, that if we are talking about monitored medicines under the real-time prescription monitoring systems, some of those systems do actually involve the system reporting it to the regulator, so to AHPRA or the relevant body. And so you may actually be picked up or questions may be asked of you in relation to that because that prescribing has been documented and captured by the system. So even if you feel that there's a legal loophole because it's not strictly illegal, it's important to remember that it is a breach of your professional obligations to treat someone unless an exception applies in a very rare acute situation. But as Solomon said, it's quite hard to conceive in this, in this day and age and in situations where regular people who don't have doctors in their families manage to sort of make arrangements for that. So I'd really just urge you to have a look at what you're doing and consider whether or not there are alternatives and take some steps to just, have that sort of system in place that Solomon was talking about and consider the Code of Conduct, not just the strict sort of unlawfulness of it, because the Code of Conduct will see you face professional conduct action.
And Ruanne, before we leave the issue of prescribing, one other question we've received is, can I prescribe a medication which is not approved by the TGA, but does help the patient by improving their quality of life? Could you give us some thoughts on that question?
Yeah, sure. So we call this off-label prescribing. And essentially that's, as Tracy said, where you're prescribing anything other than for the dose or the administration or the condition that the TGA have approved it and put it on the approved register. You can do this, and there are situations where it has become routine because there's clinical evidence to support that. But you do need to turn your mind to whether or not that prescription is based on the best available evidence, reasonable expectation of a positive clinical outcome or clinical efficacy, and obviously the best interest of the patient. So that would involve considering what other options had been exhausted. Off-label prescribing should not be a first-line treatment. The usual sort of approved methods or prescriptions should have been exhausted first. Consider your skills and experience, so involve someone else if you need to. And you do need to inform the patient specifically that it is off-label prescribing, what that means, and talk to them about the risks and benefits, including the fact that there may be risks that you're not aware of, and ensure that they are properly consented, and obviously ensure that that's all properly documented as well.
Thanks, Ruanne.
There are two issues there. There's the off-label, but there's also the non-approved medications. And if you're wanting to use a non-approved medication, you have to get an individual patient approval from the TGA.
Yeah, so these are these are approved medications, but not approved for the purpose for which they're prescribing. And there are absolutely the special access scheme and the authorised prescriber scheme for the TGA that may apply in other situations.
Thanks, Ruanne. So we might move on to our second topic for this evening, which is advertising. To kick things off again, we've got another poll question. So could you answer, how do you advertise? You can choose as many options as are appropriate for you. And of course, there are other methods of advertising. And could you put those into the chat if we've forgotten your method of choice? So while we're waiting for the answers, Ruanne, I'll just get you to give us a quick introduction to what we're talking about when we refer to the advertising of health services.
Yeah, sure. So obviously that wasn't an exhaustive list, and the advertising guidelines which support the section in the legislation, which we'll talk about in a second, cover it all. But basically, we're talking about all those things in that list in the question, together with your letterhead, billboards, any sort of pictures or images, all electronic communication, signage, books that you might write that might actually be advertising your health service, YouTube videos, other sort of content. So that'd be any of your electronic communications. Similar professional notices is something the definition also mentions, and they provide the example there of recall notices. So, you know, it's a very broad definition.
And here are the answers. And, oh, we've got a lot of people who don't advertise. Well, that's an interesting response, because I might turn to the issue of what people perceive to be the difference between advertising and promotion of yourself as a practitioner. Solomon, you're a senior specialist physician. How might a newly fellowed practitioner who's starting out in private practice, how should they approach growing their business?
Yeah, it's a real challenge, because most of our training is done in big teaching hospitals and public hospitals, and suddenly you're out in the community trying to put your sign up and trying to get business. And we are advertising in a way as specialists to try and promote referrals from GPs and other subspecialists. So, you know, the things that I did when I started out and actually continue to do is liaise with GPs, give lectures to GPs, talk to GPs where possible. I set up a website, and then, you know, part of what you do is the way you communicate with your referring specialists and GPs, how you communicate with them, the timeliness of response, whether it's really responding to the questions that they've asked, whether you're available to return phone calls. So there's a lot of ways we can make ourselves attractive as specialists to other specialists, and most importantly to GPs. I think they are a form of advertising. We've got to be conscious that we're within that code, but most of them are pretty soft as far as the sort of things you need to put in there, and most of them are really about your accessibility and how people can find you. One thing that I learned quickly is, if you do use a website with Google Maps, you do open yourself to Google reviews. And I don't think people always realize that. So once you've created a website, and Google reviews is, you know, a whole nother mess about how you feel about unsolicited reviews. But it's just important to be aware that most websites do leave you vulnerable to online reviews, for better or for worse.
Google reviews is a whole other mess, and it's an issue we're constantly contacted about on the Medico-Legal advisory line. Ruan, I might ask you to set out for us briefly what practitioners can and can't do when they're advertising.
Yeah, sure. And I've seen some questions or comments coming through, trying to draw the distinction between advertising to your colleagues and advertising directly to the public. As we could see from the list of what's considered advertising, your letterhead, which is what you're using to send a letter to another colleague, is part of your advertising. As is your, you know, might be your signage or recall notices or a business card. So just remember that when we're talking about advertising, it really is all those forms. And if you haven't already done so, I'd really encourage you to read the advertising guidelines, which are on AHPRA's website, and we'll include a link there. And just to pick up, and there is an advertising section in the Code of Conduct as well. So again, you know, read, if you haven't already ever read it, or if you haven't read it for a little while, pull out the Code of Conduct and have a read. We had a comment come through saying this should be mandatory reading for all doctors, and I couldn't agree more. Familiarise yourself with it. It gets updated when it does. We always let our members know. So it was last updated in 2020. So if you haven't read it, pull it out and have a read. And that does cover advertising. So when we're talking about advertising, basically, it's also important to remember that this is an offence in the national law. It's not a guideline. It's not a suggestion. It is an offence to advertise in a prohibited way. Your advertising can't be false and misleading. You can't use testimonials about a clinical aspect of your care, and that's defined in the guidelines. You can't encourage the indiscriminate use of health services or create an unreasonable expectation that treatment would be beneficial. And if we get time, we'll sort of unpack a couple of those things, but we are fast running out of time. And you can't use gifts or discounts or other offers in advertising without clearly stating the terms and conditions of those offers. We had another question that came through about whether or not videos that you put up on your website are considered advertising or just TGA issues. These are part of your advertising. They will also need to comply with the TGA. So as doctors, as whether or not you agree with it or feel that it's fair or not, you're bound to comply with the national law. You're also bound to comply with the general consumer law, which is that advertising can't be misleading or deceptive or likely to be so. And that's picked up anyway in the national law. And you also need to comply with TGA requirements, which are things like not using named medications or including that in your advertising. So there's a lot to cover. Read the guidelines, read the code.
That's a very clear answer, Ruanne. Thank you. Dan, I might turn to you. The recent changes regarding advertising, do you have a feeling whether those changes are being acted on at the coalface?
So, Tracy, there's been there are two documents here that we need to talk about. There's the general advertising guidelines for medical practitioners, and then there's the special subsection of regulations for cosmetic surgery, because the whole cosmetic surgery industry has been shaken up and regulated more strongly. And so AHPRA has a very strong intent to not only respond to complaints about advertising, but actually surveil advertising in that cosmetic space. Initially, it's about cosmetic surgery. However, very soon it will roll into cosmetic medicine as well. And the standard for your advertising in those areas has been lifted quite dramatically. It's not just the fact that you can't use testimonials, you can't respond to comments that's considered to be acknowledging that as a testimonial. It's not just that you have to put your medical registration number and your specialist qualification or whatever is appropriate there on your website, your business cards, what have you. It's also very detailed around things like the language that you use. The language can't be pejorative. You can't use the term anymore, mummy makeover, because it's an offensive and pejorative term. You can't say that because somebody's had babies that there's something wrong with them. And I think that you've got to look at the principles behind these regulations, and they're designed to protect patients from practitioners or businesses, for that matter, who are trying to push services. And we have to see that what's legitimate and viable here is providing information to patients, but what's not legitimate is creating a desire or creating an unnecessary health service situation.
Yes, and so you feel that people are actioning the changes, particularly for the web-based materials?
Sorry, Tracy. Yes, I have seen a very significant uptake of action. People have cleaned up their website. When I was looking at these websites 10 years ago, it was egregious what was on there. Now, I'm not saying it's perfect now, but the websites have changed dramatically. So there were huge numbers of websites with what the general public would have considered pornographic images on them. And those have been cleaned up. AHPRA has taken it very seriously. And for all the problems that they might have, this is something that they've jumped on quite seriously. And it's black and white. It's, what is it? Black letter law. So it's pretty easy for them to enforce. It's not like your professional judgment where they have a real struggle determining whether or not you've done the right thing. There's no discretion here. There are very, very clear-cut rules, and people have to abide by them, and they are. Certainly in my area, in my colleagues have abided by them. What we're going to see next is tightening of the regulations on cosmetic injectables, because they've been sort of left to last at this point.
Well, given the black letter law, let's look at the penalties that are imposed for breaching those advertising laws. And they are, as you said, Dan, very significant for the breaches. Ruanne, can you just give us an overview of the penalties involved?
Yeah, sure. So in terms of advertising in a way that breaches the Section 133 of the national law, the penalty for that per breach for individuals is $60,000, and it's $120,000 per breach for corporations. This applies in all states and territories except WA, who didn't update their penalty provisions in the last round of changes to the national law. So in WA, it's still $5,000 per breach for individuals and $10,000 per breach for corporations. When we're talking about offences also, in terms of how you describe yourself in your advertising, and this applies not just to those advertising cosmetic surgery, but if you're using words about specialty titles or protected titles in your advertising, the penalties for that are the same as for advertising in the rest of the country. So $60,000 for individuals per breach, $120,000 for corporations, except in WA, where this is $30,000 for individuals and $60,000 for corporations. So, I mean, either way, significant penalties. And there is some additional guidance in the advertising guidelines about things like using words like specialising in, which is generally warned against, and people are encouraged to instead to use words such as working primarily in or focusing on, and those sorts of terminology. So again, have a look at what the wording says and how you want to consider your advertising.
Thanks, Ruanne. And I think we should go on to our final discussion topic this evening, which is artificial intelligence, or AI. And it seems to be mentioned everywhere at the moment. We don't have a poll question for this topic, but we'd be really keen for you to put into the chat any current AI tools that you might be using or you might have heard about in the healthcare space. We've all heard about ChatGPT, of course, but there are many other AI initiatives coming through, the Lyrebird. And while we at Avant are learning about AI, Ruanne, can you give us your thoughts about the application of AI and particularly generative AI in healthcare?
Yeah, sure. So again, this is obviously a big topic, and for the purpose of tonight is just to use a bit of a screen, sort of a bit of a snapshot, and talk about generative AI. So where it's generating, you're putting information in, and the tool itself is generating text, images, software code even. I think it's really important to think about technology supporting developments and benefits in the delivery of healthcare, whether it be in access, efficiency, accuracy, whatever that may be. Of course, the natural instinct as a lawyer is to turn to the risks, and those might be the accuracy of content, privacy and confidentiality concerns, because obviously you're sharing information with that tool. The tool is capturing, the tool is also using it to learn, so it's actually influencing future outputs and information that's generated by that tool. And also your professional obligations and integrity. If you're writing clinical notes or a medical report, you as a practitioner have an obligation to ensure that you've applied your clinical expertise and judgment to that content, that it's accurate, that it's up to date. We've heard, some of you may have heard about the recent case in the US where the submissions were actually generated using an AI tool with references to cases that, even though those preparing it had asked for it to check what the references were, it actually just generated fake references. So it's really, trying to strike the right balance between recognizing that this is a great area of opportunity of technological development that supports efficiencies, but there are risks that need to be closed off, and you can't just use the tool to spit something out and hand it in as if, you've done it yourself.
Absolutely. And there are a lot of examples coming through in the chat. Dan, I would have thought from a clinical perspective that there would be scope for AI to be incorporated into your scope of practice.
Yeah, Tracy, I think probably the most obvious example would be that a number of skin monitoring programs are beginning to use AI to assess melanocytic lesions. And I think the important thing there is to assess the risk and to go with the herd, to look at what your professional association is saying about the quality of these things before we introduce them into general usage. You don't want to be the key opinion leader if you don't have the key opinions behind you. It's got to be a consensus situation if you're going to introduce AI into an area of clinical judgment like that. Yes, it can be useful. I mean, there are uses. I mean, some of the things that have been described in the box, like the radiological uses, can be really useful in craniofacial surgery for planning and for pre-cutting bones in craniofacial operations. But you do need to be sure that you're using something that is considered to be safe and reputable by your colleagues. It's about being in a safe zone, and it's also about understanding the risks of AI. And I think, Ran, you have talked about the issues of writing reports with AI, where confidentiality can be lost, using AI to write papers, where sometimes there can be a lack of perspective. So, we do have to keep tabs on these things and understand the strengths of AI, but also understand where the risks and weaknesses lie.
And that's very sage advice when you refer to being consistent with your peers, because if you have to justify your actions through the use of AI, you would need a peer to support what you have done as being reasonable practice in those circumstances. So that's very sensible advice. I might turn to Solomon. Do you have any thoughts about the application of AI, particularly in relation to, say, processing of pathology results to overcome resourcing issues? There's been reference to that in the media.
Look, I think it's an exciting time to be a medical practitioner, because there seems to be a lot of innovation that can evolve from AI. But as we've all said, we've got to be cautious and make sure that it's reputable and reliable. Certainly, a lot of the churning through results and reviewing of documentation and making sure that results are within a certain range, which we do manually or rely on labs to do, would be something that could evolve to AI to make sure that we're notified about outlying results or outlying issues. But at the end of the day, individual patients are coming to our rooms for an individualized opinion. And if we try and use external resources, it doesn't actually help an individual patient with all their risks, benefits, or their comorbidities. I think we've got to be a little bit cautious to move from a patient-centered approach to something that's churned out through artificial intelligence. But having said all of that, I think if as a fraternity we work with AI and work out where it would work very well, and we talked a little bit about dermatology, radiology, things that are far more visual, that's certainly something that would be exciting. And as we said, just processing a lot of what we do that's fairly mundane, I think would be very exciting as well. But again, you've got to be careful to hand over report writing to a computer when you haven't got a patient in front of you.
Thanks, Solomon. And that indeed leads us to a number of questions that have been coming through about whether tools can be used for writing medical reports or medical notes. Some of the questions we've received: are we allowed to write medical reports with AI? Should we have any concerns about the use of programs like Lyrebird that use AI to generate notes and a consult and referral letters? So I might ask Ruan, do you have any thoughts about those questions?
Yeah, so they sort of all fall into the same category, and it's really about closing off or considering what the tool is doing or what you're asking it to do, and what you're doing with what it generates. So issues about where the information is stored, whether you are required to input sensitive or personal information about the patient into the system, and what it does with that information once you put it in there, whether it stores it overseas, whether it uses it to learn, and therefore is storing it in the tool, and then what you're doing with what it spits out. So it's about applying that. It's about critically analysing each of the tools, much like when we saw the introduction of telehealth. I think in time, maybe something like the Digital Health Association may, actually have a deeper look at some of these tools, and we're starting to have a look at those. But it's about thinking about the tool, how you're planning on using it, and addressing the risks that may be posed by that tool in terms of privacy and confidentiality, sort of accuracy, and your professional skills and expertise and integrity, and making sure you use it in the right way.
I might ask you this further question. Is it okay to use AI technology to record a patient's consult in order to get a printed version of the summary of the consult?
Yeah, so if we're talking about audio recording, whether or not we're talking about AI or more simple forms that a few years ago were still considered quite revolutionary, such as your mobile phone, which all of us, generally have with us when we walk into the doctors these days. It's important to be aware that, again, in our federated system, there are different state and territory regulations or laws in each state and territory about whether or not you can record that in the first place, and what you can do with it once it's recorded. If you have consent from the patient, and there can be benefits in recording something, and it would apply in an AI context too. If you have consent from the patient to record that, you also just need to think about how you're going to store it, whether a recording is going to form part of the clinical records. And this might, in an AI context, depend on how that might be talking to your software system, whether or not you do record it, whether or not you keep a recording of it, and what it's spitting out, again, so that you can make sure that that is accurate in terms of generating a transcript is not necessarily a useful clinical note in terms of your overriding obligations to make a note that is useful and comprehensive and contemporaneous. For example, if you were handing over care to another practitioner.
Thanks, Ruanne. Now our time's coming to an end this evening, so I might ask for some closing thoughts from our panelists. Dan, I might start with you.
Sure. Thanks, Tracy. Look, I think that with many of these things, documentation is essential. Good documentation protects you. Good documentation shows that you've thought through the issues, considered what's appropriate, and you've made a choice. I think that you want to think about what your professional society has to offer and has to say on these issues. One of my friends who's a senior trainer, he'll say to the divergent trainees, stay close to the pride Simba. And it's absolutely true. When you go off as Robinson Crusoe, you're going to be far more likely to get yourself into strife. So knowing what other practitioners accept as a standard and understanding what the society that you belong to, the professional group that you belong to, expects as a standard is incredibly important. And they will often have the ability to negotiate for you with legislators, with insurers and so forth, to better understand the nitty-gritty of the regulations and be able to give you something that makes sense in your area of practice and can convert a general statement into a very specific statement for your area of medicine.
It's a wonderful analogy, Dan. Thank you. Solomon, I'll turn to you. Your closing observation?
Yes, I just avoid anything with the prefix self. I think that's the key message from tonight from me. You may think, and many of your peers may think, self-prescribing is not unreasonable. One thing's for sure, pharmacists are well attuned to the requirements and the recommendations from the board, and they will not think that's acceptable. So self-prescribing, self-referring, self-investigating, all those things really strongly ask you to avoid. It's really bad medicine, bad practice, and bad for you.
Thanks, Solomon. Finally, Ruanne, can you give us your closing thoughts?
Yeah, my closing thought, Tracy, is going to be a recommendation for a great read. In fact, 3 great reads, depending on what you do. One is the Code of Conduct. Read it, have a look at it on the web. You can read it on your phone, you can read it on your computer, print out a copy if you're old school, but read it. And I'd really encourage you to read it and regularly revisit it. Read the guidelines about advertising. And if you're a cosmetic surgery practitioner and you're advertising cosmetic surgery, read those. The AHPRA have a great advertising hub on their website. We're regularly in contact with them. So if you have concerns or we identify concerns, we raise them. But, I'd recommend that you all, on your way home tonight, or if you're already at home, have a read of the Code of Conduct and follow it.
Not if you're driving home, of course, but great recommendation. Thanks so much to all of our panel members, and please be aware that the information which has been provided this evening is general information. If you need specific advice, then you'll need to take advice from your lawyer. If you have any further issues you'd like to discuss, please contact us via our website, avant.org.au, or by phone to our Medico-Legal Advisory Service, 1800 128 268. Can I also remind you to have a look at our wellbeing app on our health and wellbeing page. This app allows you in only 2 minutes to monitor your own well-being and access many helpful resources. It is completely anonymous, and it's really worth a look. We'll be doing these webinars regularly. Thank you so much for investing your time with us this evening, and we would really appreciate if you could complete the survey, which will be sent to you to let us know what you thought and what else you'd like us to talk about. So thanks again, and bye for now.